it may well be indefinite. And the parole board will have to make the decision in due course whether it is ever safe for them to be released. And the criterion which will determine their relief is whether they pose a risk to public safety. It was a classic example of how to conduct a sentencing exercise. I mean, sentencing of anybody, particularly of juveniles, is highly formulaic. And it is a misconception to think that the judge has much in the way of discretion. Once you've made the factual findings that the aggravating factors and balance, in the case of Eddie, this was balance the mitigating factors. I mean, you're left with the way you're left with your starting point. In Scarlett's case, the aggravating factors outweighed the mitigating factors to a modest extent, and there was a modest uplift. But as I say, it was highly formulaic. But Mrs. Justice Yip did express herself in a way which is very important, which is that ordinary people could understand what was being done.
Yeah, I thought as well she laid out quite clearly that particularly there in Scarlett's case, because there was a lack of remorse, a lack of empathy, there was continuing to be ideas of future killings, that she was going to have to do a lot of work before any sort of parole board would consider letting her back out.
Indeed. I mean, the underlying message was, I mean, the minimum terms. I mean, they had Parliament. The statute says they have to be imposed, but the underlying message was, if you will ever be let out, I can't predict, because the nature of the crimes is so horrific and so remorselessly evil that for the parole board to be able to decide for either of these young people to be let out is going to be very, very difficult to predict.
Indeed. Now, I can almost, I've been around long enough that I can almost write the headlines in some of the red tops tomorrow of how this is, a betrayal, a disaster. They could, with could doing a lot of heavy lifting there, be out by the age of 35, etc., etc. But I mean, I think we should just be a bit cautious here that as the judge tried to explain, that there, for that to happen, an awful lot of other things must occur.
Yes. I mean, the minimum sentences are what is written on the tin. They are minimum sentences that even if they were completely rehabilitated and behaved impeccably, they could not be let out earlier than that. But what the judge was emphasizing is that it may well be indefinite. And the parole board will have to make the decision in due course whether it is ever safe for them to be released. And the criterion which will determine their relief is whether they pose a risk to public safety.
And
So
I thought sorry, carry on.
No, you're right. One can predict what the headlines in the tabloid press will be, but it's just completely to misunderstand the nature of the sentencing exercise, which is to fix a floor below which you cannot go, but above that is going to be for the parole board to decide by reference to the criterion of public safety.
And I thought as well, in terms of laying out with clarity why she was naming children who, for whom they committed this crime at the age of 15, technically in the eyes of the law were still children, why she would do that. And, I was trying to think back, and the last time I can kind of remember anything with this sort of public interest argument would be the Jamie Bulger killers with Robert Thompson and John Venables for kind of the same reasons.
Yes. I mean, it was inevitable that they would be named. Absolutely inevitable, because, I mean, open justice is an absolutely fundamental, core, critical constituent of our constitution, that justice must be seen to be done. And in cases of this nature, the crimes are so serious, it's unimaginable that they wouldn't have been named, in my opinion. I mean, of course, there has to be a balance between their rights to a private life. Well, they forfeited that, really, as against the public's right to know. So their being named was inevitable, in my view. And as you rightly say, Venables and in the Bulger case, they were named. But now, with social media being so ubiquitous, I mean, it would have been futile not to have named them in any case.
And in terms of the view that Mrs. Justice Yip took, that while the stories had changed from both of them about who did what, who struck the kind of fatal blows, and there was 28 stab wounds, and who had blood on which part of the clothing and all the rest of it. I mean, she was pretty clear that because they were both involved, they could both be deemed culpable. Yeah. Is that common in this? I mean, this is a very unique crime, but is that common where you can't really discern who's done what in terms of a multiple person attack?
Well, yes. I mean, this was a cutthroat defense, wasn't it, with each blaming the other. But the nature of the defense was that for each of them, they were admitting to being an accessory. I mean, they couldn't, and so they're liable to be convicted and sentenced as if for the full offence. So the defence, so far as I could tell, went possibly to mitigation. That's all. But and so I couldn't see any reason at all where it was a group. It was a joint enterprise of these two young people. I can't see any reason why, irrespective of who dealt the final blow, both should have been named.
Yeah, and I thought one of the other consequences that I thought was quite interesting was the idea that even though actually neither of the two killers were particularly mature, Scarlett particularly immature, saying that Eddie had social skills of a much younger age, was able to say that actually that level of maturity didn't get to the point where it would be considered necessarily mitigation because you knew that what you were doing was wrong. Even if in the case of Scarlett, she didn't feel that it was wrong. She enjoyed it, that she got off on it, but that she knew that it was wrong and it was not a compulsion. She would have been able to stop herself from doing it. I mean, I thought that was really clearly laid out there, but I didn't necessarily.
Well, I agree with you that the judge made it abundantly clear that the value of the mitigation was outweighed by the personal responsibility with which these two had to be fixed.
Indeed. Look, thank you so much for explaining all of that to us. These things, to lay people who haven't been involved in the court all the time, they can be, terribly unclear. So we do appreciate you giving us all of that analysis there. That is the former High Court judge, Sir Nicholas Mostyn.